Hello, everybody. This is Mr. Kirkland at the HQ office. Um, my name is Dwayne Kirkland. I am a self-claimed constitutional advocate, self-claimed constitutional officer, and I basically work behind the scenes to expose judges, lawyers, and police officers um, for due process violations and high felony treason, and also a variety of other different violations when it comes to the Bill of Rights or in concern of the Supremacy Clause and the equal protection of the law for American citizens. I'd like to start off to let you know I want to share with you of my investigation of study of law, which here's some information that most don't know. There's a lot of attorneys don't even know this stuff because this is what the judges have hidden behind their books that tells the judges how to do their job, even though they're supposedly supposed to be the referee. A judge is not supposed to be impartial or unfair, basically, during due process. He's the referee, the trial factor. He's supposed to not act like the prosecuting attorney, and he's supposed to go by the law and always preserve and honor his oath to protect and preserve the Constitution at a state level and federal level. But most don't know this, that's what their job is. It's got way out there overreach and infringement and encroachment, and basically enforcing legislative fiat, basically laws made up by non-lawmakers, basically. That would be code, statutes, rules, regulations that have no actual authority unless you consent by a contract. But we can get into it all day long on my opinion and my experience. But what I'm going to start off here, this is just, I'm going to read one page out of 77 pages, and I'm going to elaborate on it a little bit as I did on my opening statement. Well, here's the merits for American Jurisprudence, Book 16, Constitution Law Sections, 16th Amateur 2D. Okay, so this is basically the law books of constitutional law that is hidden and only for judges. They usually have these books behind them, right behind their desk and their big chair, and those are the books that tell the judge how to do their job. And if you actually start reading this stuff, there's case after case. Gets into Shepard citations. There's recorded case laws, hundreds of them. That is just amazing, and it'll just totally blow your mind, and it'll show how far off these judges and lawyers and police officers have encroached and infringed and violated the contract that they're bound to and where their powers come from. So, however, again, American Jurisprudence, Book 16, Constitutional Law, Section 16th Amateur 2D. We're going to start off with, actually, I'm going to start off with the bottom one, and I'll work my way up to the top one. There's so many of them, but I'm going to start off with 16th Amateur 2D, Section 155. Now, this is what 16 Amateur 2D, Section 155 tells the judge. It says, since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, the courts are not at liberty to overlook or disregard its commands or counteract evasions thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions and in respective of the consequences. Thus is said, thus it is said that the court should be and are alert to enforce the provisions of the United States Constitution. I got to find the other page here. We're missing Oh, here we go. Excuse me. I'm sorry about that. The United States Constitution and guard against their infringement. That's what I said, right? By legislative fiat or otherwise in accordance with these basic principles. Whoa. Do you want to know what the basic principles are? I'm going to tell you right off the bat. We already know what legislative fiat is, right? That's conflicting laws made by the lawmakers, period. We're talking also the laws that are made that are not made by lawmakers. Basic civil high school government, civil government would in the 11th grade would tell you what the basics is of basic government. Okay. But anyways, when we get into that, what I want to get into is it'll come back to me on when I need to, but what I need to focus on right here is finish reading this part. But as I stopped here where it says these basic principles, I want to tell you what the basic principles are. The basic principles are fundamental principles is amendments, provisions, articles, declarations of rights at a state level and federal level, and anything in the Constitution that's written under the enumerated powers. The Constitution only has actually 7 articles. It's pretty easy to pinpoint those down. The most important article of all of them is probably Article 6, Paragraph 2, which basically stating and telling that the judges are bound, the lawyers are bound, and the cops are bound if they have that authority granted to them by oath. And the oath is by promise to what? Our God, period. But I don't want to get into that because that's just really would freak people out when they know that every state and every official government person made a promise to God. And there's a lot of people out there that are fighting against that little contract. But that contract can never be changed. It can never be sold. And they would never have enough people to vote against it, period. But anyways, okay, so I told you what the basic principles are that the judge is supposed to protect and preserve. Not only the judges, I also mentioned the police. I also mentioned the attorneys, lawyers, government institutions. They're bound to this, period, okay? So further reading on from finishing this paragraph says, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the delivered judgment of the tribunal court, basically, before which the validity of the enactment is directly drawn into question. If the Constitution prescribe, okay, first of all, let me tell you what that part that I just read would probably, what I think in my mind and what I believe is basically you're going to file a declaratory judgment on the justification of whatever code they're trying to say to justify their actions against you, period. And I guarantee you every code and statutes and rule and regulation that they throw at you, you got to object and file demand. You have to demand for a declaratory judgment in writing by affidavit. And then that's when you can come up where you have another judge that is actually a judge that knows the Constitution and actually follows the Constitution. He will tell you if he will give you a final judgment on whatever their code they're using to justify and tell you if it's either unconstitutional or not. And even though it's even judges in an act position in the higher courts also do the same thing that the lower courts do. So you're going to have to, if that judge doesn't make the right decision and you know that by law that you know that is real law, then you have to appeal that process and go up to the next step. But a lot of times it really doesn't even go that far. Usually there's some good judges out there, and I think we're changing them out pretty quick. So I'm pretty happy about that. So let me furtherly read on in this paragraph. It says, if the Constitution prescribes one rule, okay, and the statute, code, regulation, made up law, legislative fiat, a whole list of them, as far as the eyes can see, they got miles and miles of them, says statutes, rule and the statute, the another in different rule. So if there's a conflict in another rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. So this here, again, we'll go back to 16th amateur 16th amateur jurisprudence, book 16, the books that tells the judges how to do their job, basically says 16th amateur juror 2D section 155 says they have to give you judgment in your favor, period. That's their job for the Constitution. They can't go against it. So that's why it's so important to know that you can't supersede the Constitution. And what's really interesting about that is every state says the same thing, except for you do have a few handful of states that covered up with legislative fiat or fraud, pursuant to fraud. So that's another issue of showing how to go ahead and reach into the enabling clauses in the history of the laws that covers up each law. Because when a law is made, it cannot be negative. It only can be positive to the original law prior to it. And you have to go all the way down to, all the way back as far as you can to see where they did the fraudulent change in writing and change the narrative of the actual law. Okay. So that's something else. That's another whole thing to tell you later on that I discovered too. Okay. So I hope that's kind of clear on that. Let's get back to, that was 155. So we're going to go to 117. Okay. 16th amateur 2D section 117. Various facts of circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. I can't even pronounce the word. Unambiguous, unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument. So they can't overreach to change the actual wording of the text of the Constitution. It tells you that. And okay, so let's go up to one of the ones that I think is important too, that the public should know, and I think attorneys should know this, cops should know this. Judges either know it either by error. Judges either know this or they just don't. They're really ignorant or dumb. I don't know, but half the judges the judges that I encountered personally, when I even mention any one of these to the judge, they usually melt in their chair and their mouth drops and they change their whole tune immediately. Sometimes even these I've used to utilize these in a response when I gave them permission to give me their opinion on a case that I was fighting. The judge himself or herself would write a response from what I wrote, and then I would agree to it because I said in the beginning and standing in court said, look, Your Honor, you make the decision on this. You're the judge. I believe in you and I believe in the system. And they would give their opinion basically like an attorney would. And then when I got that documents, and even though they didn't rule in my favor, I still responded to them behind the scenes. And when I respond behind the scenes, an objection to theirs and show my argument of this law here, of the law that he understands and he knows, 50% of the time, the judges feel so bad. And, well, I'm going to tell you one judge, there's a couple of judges in my experience that I did that to, and they retired immediately. And they probably, to this day, is probably drinking and drunk because of all the people they've harmed and all the wrongdoing they did. But I'm not going to get into all that. I'm not the judge. God judges them for their actions. But let me go back to the one thing that this paragraph here I want to read. It says under 16th Amateur 2D, Section 98. Now, this is Section 98. It says, no emergency has just cause to suppress the Constitution. No emergency has just cause to suppress the Constitution. Now, here's what it says in the real law. While an emergency cannot create a power and no emergency justifies the violation of any of the provisions of the United States Constitution or the state constitutions. Now, why is that? because the state constitutions were actually there before the federal constitutions, and then they were in harmony under a contract and a compact agreement between all the states that joined the union. And then when they created the federal government as a whole to protect the nation's freedom and preserve the Constitution, the federal part had to make a supreme law of the land under agreement in harmony with the Constitution. So they all have to be in harmony. So that's really important. Let me give you an example how you can do a speedy check on something that if you're not sure about. Take the Constitution of one state, take another Constitution of another state, do 3 states, put their constitutions on the table and read them. One out of those 3 are going to be a little way off. They're going to be worded and numbered differently to trick the ignorant and the ignorant people that don't, or not really ignorant people, but people that can't read, or people that don't even pick the constitutions up. They're designed to trick people by under the way their orders are and their numbers are and how they're in order, and they're scattered and switched around. But really, if you really read the merits of it and you read those 3 states' constitutions, they're supposed to be in harmony, and most of them are in harmony. But there's, like, let me give an example: New York City, DC. Well, let me tell you. Let me give you a better example. DC's bad. New York City's bad. Okay, that's one of the states that are really bad on when it comes to the real law. But California is a perfect example. You can see where they changed it compared to other sister states. So that's fraudulent. That's fraud. That's actually high felony treason. And if you want to get into the criminal part of it, but I'm not going to get into that right now. I'm going to finish reading this. So we know no emergency has just cause to suppress the Constitution, right? So I'm gonna leave that at that, because I elaborated on my own words, and I mean I can read more into this paragraph, but I want to jump up to 16th Amateur 2D section 97 now. It says, then a constitution should receive a literal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to person and property. And then it also throws a case law right behind it. Berry versus United States, 273 U.S. 128. Wow, outstanding. Well, we're in 17 minutes and 33 seconds. I better stop right there. I can go on and on. Let me see if I can find one more short one to read. Let me see what I got here in my paperwork. Okay, I've mentioned Title 18 U.S. Code Section 2381 before, and I mentioned Title 5 U.S. Code Section 556, Section 557, Section 706, and other readings. Title 18 U.S. Code Section 2381 basically says, in the presence of 2 or more witnesses of the same overt act or in an open court of law, if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office, you are subject to the charge of capital felony treason. That's one of the ones I actually used to melt that judge in Texas when I was on the phone with the client. See, I'm not an attorney. I'm just an advocate, and what I claim as myself. I would never say I'm a real cop, or even though I say self-claimed constitutional officer, that basically just saying that I'm a scholar of the Constitution and I study it 24 hours a day. It's my whole life because of me being a victim. But that doesn't mean I'm claiming to be a cop. But actually, under the authority of the 10th Amendment, I actually can claim to be whatever I want to be, because I can take the power back from the state or the federal government when they violate any of this stuff that I'm talking about, and the power goes back to the people, which I'm one of the people. So I can declare that. But I mean, I don't want to just do that to destroy our country. I want to teach what I've learned that works, and this stuff works. Okay. Now the other code is the one that I always elaborate on is Title 5 U.S. Code Section 556D, Section 557, Section 706. Now that code under that Title 5 there is basically easy. It says courts lose jurisdiction if they do not follow due process of law. Short and sweet. Anytime you can prove in writing or with 2 witnesses or more with those 2 titles that I told you, you can eat them up all day long, and you probably won't even have to go to court. You can probably just put it in paper, writing, put it in as on the record. I guarantee they're going to want to take it off the record real fast, and make sure you have 2 witnesses. Then they have no jurisdiction. if they violate any of the constitutional rights. And one of the main points that I told you earlier in the reading: number 1, fundamental principles; number 2, provisions; number 3, amendments. I mean, actually, I always say number 1, fundamental principles; amendments, provisions, articles, and declarations of rights, and basically anything in the ironclad contract. So it's important for you to read that ironclad contract, the compact agreement between the states and the federal government. It's very important you read that. Okay. Oh, on the jurisdiction issue, they really have, actually, by law and depth of it, and you really study it and you get in the depth of it, really they have no jurisdiction on you at all unless you consent to it, or if there's an actual victim or property damage, or you violated the Constitution at a state level or federal level. Period. Remember that. I'll say it again. Well, I won't say it again because I got a brain cramp, but it'll come back to me again here. But anyways, let me see if I can find one more. I'm excited here just sharing this stuff. Let me find... okay. Here's one I really love that I like, that I really studied. And to me, this is the lock. It's called, the most powerful lock there is in the world when it comes to a lock, in my opinion, when it comes to law. The U.S. Constitution, Bill of Rights, Article 9. I would read that if I was you and study it, the history of it, the enabling clauses, when it first originated and what it meant. And every state says it. Every state says it. They have their own enumerated, it's in their own little declarations of rights, of their own Bill of Rights. And it says the same thing. Okay, this is what it says. It says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The enumeration in the Constitution of certain rights shall not be construed to deny. Period. They can't deny any constitutional rights. Basically, they're locked in. And the Article 9 locks it in. So your Article 9 alone, in argument, it can, anytime that they violated or violated your rights of those principles and those amendments and the stuff that I explained to you, you can just write down in, they violated Article 9. So if they violated Article 9, it's very simple. They violated Article 9, so therefore, Title 18 says, what does Title 18 say? They committed high felony treason under Title 18 U.S. Code Section 2381. What else does it say? If they violated number 9, Article, the enumerated powers, if they did prove to you that they had jurisdiction over you, they lost it under Title 5 U.S. Code Section 55D, Section 557, and Section 706. According to real law, courts lose jurisdiction if they do not follow due process of law. So if they ignore one of these articles or one of these provisions whatsoever, they lose jurisdiction, period. But that's if you get in the battle of it. The most simple thing is you want to just stop them right at the beginning and don't contract with them verbally and put it in writing. Anytime you find yourself in front of that judge talking and they're reading an alleged crime to you, first of all, you want to find out what distinctive difference of what if it's a civil issue or a crime issue, because that's where you're going to base your argument on. But I like to throw both of them in there. I put the civil and the criminal in both anytime I'm in front of a judge, period. So, I think I will leave it at that, and I'm going to call it good for now. It looks like 23 minutes and I'll go on 25 minutes, 24 minutes. I want to say thank you for listening. If you have any questions, contact my office. I will love to speak with anybody to share the discovery and my learnings and my experience of me working behind the scenes. I will say this, they do block a lot of my information, and I am targeted. I'm on full alert. I'm in danger, basically, because of the stuff that I know. But however, I'm not too worried about it because I'm a believer of God, and I believe God has guided me, and this is my calling. But however, I want to say thank you again for listening. God bless you. I love my country, and may you get a hold of me. Oh, I'm going to give you information of of how to contact. We're going to go P.O. Box 32, London, Arkansas, 72847. Again, P.O. Box 32, London, Arkansas, 72847. That is my P.O. Box address for communications in writing, and also if donations to Dwayne Kirkland, which is me. I'm appreciated for all donations. I get donations once in a while, and I'm very happy when I do get them. It helps me out a lot. And then my phone number is 1479 336 9084. That is the private number on me. And then there's additional numbers you'll find in that. Sometimes they'll be off for a while and they'll be back on no matter what. It's just certain times I turn them off for security reasons, and then I turn them back on. The other information would be my emails, provisions@mail.com, and then officerkirkland@icloud.com. Okay, well, thank you so much for listening, and God bless you, and I hope this reaches out to the masses. Free the masses from the slavery of codes, statutes, and regulations. God bless you. God bless America, and I love you all. Bye-bye.